Welcome back to our coverage here. The Supreme petition, the wait continues at the Supreme Court for that audit report. We have been waiting for the last 1.5 hours, I think, but we'll keep waiting here. Let me just take you through some of the arguments that have been made before this court so far. Remember, I mentioned that as we speak now, all the parties that were supposed to make submissions have, except for this little matter of access to the servers and the forms. And some of the arguments that we're putting up just now that have come from the various parties. For example, we have had NASA made their submissions, and they have been talking about the different aspects, whether it was the forms that were supposed to have been uploaded. Okay, first of all, they talked about the 14 constituencies, and they said that the ROs, the returning officers, were ungazetted. They claimed that there was a formula, a very interesting formula that has been the subject of all manner of conversations, but they said there was a formula that was used to give the president that win. The IBC on its part has been talking about results on Form 34Bs as being the primary document they were supposed to use in declaring the results, and not, they had no business with Forms 34A. They said that there was no requirement to stamp ballot papers. The only requirement was for, there was a requirement for stamping ballot papers and not the forms. The IBC further says that not all Form 34s could be scanned and uploaded in time. They've also talked about the hosting of their backup system, which they say was completely above board. The chairman, remember, he is also a respondent in this case, the second respondent, Fula Chebukati. He says the petition was an afterthought. He says the scrutiny of the electoral systems, which, by the way, has delayed now, but he said that scrutiny would vindicate him in this whole thing. Then there was the hacking claim, which he says was a fallacy. It wasn't a big issue in this petition, but he says the case has not been supported by evidence. That is what the chair said. The president, on his part, saying that his party, Jubilee, won a majority of the seats, and that should be evidence enough that this wasn't an isolated incident, his victory, that is, that this was a pattern. He also says that there was no contest on the transmission, the forms, and so on. But he also says that his 54% win was consistent with many projections, including the one for ELOG. Says the discrepancies that have been talked about are totally insignificant. Actually, some of his lawyers have referred to them as simple errors and mistakes that should not be used to invalidate a presidential election. And we've had many arguments back and forth about this. Let me now welcome to our discussion Joy Brenda Mdivo, not a stranger here, but also an advocate and a former magistrate, by the way.
Yes.
Yeah, and so you probably know what happens behind the scenes when we are not looking. What could those judges be doing? I mean, they made an order. There seems to have been a delay with some reports. Are they now sitting somewhere and saying, what do we do? Everybody's gone to reading their briefs and looking at what could those judges be doing behind the scenes somewhere?
A prudent judicial officer, like we've seen with these ones, would not just wait for the hearing to start, for them to start forming an opinion one way or another on a matter, but will have studied the pleadings that have come before. And remember, the judges made an allusion to that fact when they said, oh, we haven't slept for several days. Yeah. That's what they've basically been doing, studying the case.
Or since they
understanding
got
it. Since the pleadings came in, as the responses came in, they've been appraising themselves the matter. That is why you find even when they're in court, they're able to engage with the parties. When you make a statement, if it doesn't add up to what they had understood, they seek a clarification, because in their minds, they already have an idea of where
what
this matter
everyone
is going.
Saying. Yeah.
Exactly. And what I would anticipate that has been happening now is that the judgment is already being written, because how you do a judgment, basically, you start by laying down the facts as have been laid down by the various cases.
Which have been coming through anyway as the case.
And because that is the part that takes a lot of time, because you're actually restating what has already been stated. So I'm sure that part of the judgment is already in the computer somewhere with the stenographers and the people who've been taking the notes, just helping them to put down the facts as have been laid by the parties so far. What now we are waiting for is the final piece of the puzzle in terms of the evidence that is being are presented, because once they're done with that part, then they come to breaking down the reasoning that has been put by the parties. After they're done with that, then they come with their own reasoning. Now, this is where it becomes interesting, because you can have the potential of the judges having a conference, having a discussion and coming with a consensus position, or you can have a situation where each of them decides, you know what, when it comes to the reasoning, let me be my own man. So either you can find that you have similar judgments, or you can find that you have dissenting judgments. So it's in the reasoning of the judges where the variance comes in. But what is going on right now, even with the preparation for the judgment for Friday, is the more mundane part that is predictable.
So how much conferring happens, how much consultation happens, because you have a bench there of 7 people. Well, right now, Mohammed Ibrahim is indisposed, but what exactly, in terms of consultation, how much of it rather happens?
They do what you call conferencing. So this can be done in several ways. You can either split up the case into several bits and pieces and say, you go think about this, you go think about this, you go think about this. Then you come back and sit down, and then you tell the rest of us what you found out in your particular area. We saw like what they did with the amicus parts. Tell you, you go research on this, you research on this, addresses on the same. That's one way of doing it. Another way of doing it is in deciding to go through the entire thing by themselves. Now, that is not only lengthy, it can get to a place where it becomes a bit muddled. So I would imagine that the assistants, the people who are doing research for them, must be working round the clock. For example, the ruling that Judge Lenaola delivered on the whether or not they get access to the servers. You could tell that that judgment was written by a very skilled judicial officer, but there are some technical parts which I would be surprised if the judge was in particular knowledge of those issues, because they sounded very technical and very intricate. So you would imagine
very
that
specific. They seem to be giving very specific
so
things.
There must be some experts or some people who they're also consulting with on the more technical aspects of the case.
I was going to ask you a more direct question now that you have mainly on the other side. We're at this stage where everybody has made their submissions and that sort of thing. Of course, there's still this outstanding matter, but those lawyers, what are they thinking about? I mean, you've done all that you could do probably for this case. Are you making your own impressions of it? What happens?
First, I was going to say one thing before I get to your answer. That I think we need to encourage our courts, especially the Supreme Court, to adopt best practice internationally. And those include where the judge does their own research and write their judgments in terms of comprehending the entire case. Because that way, you help develop jurisprudence. That's how you know, for instance, in the US, you know certain judges are conservative, this is liberal, or those who are in between, and you can predict potentially how is your case going to be, and therefore informs your preparation for that case. I know that our judges, both in the Supreme Court, Court of Appeal, and I suspect High Court is getting there, we have researchers who have been appointed now by the judiciary to help them to do research in terms of when they are isolated issues. Coming to the question you're asking about what impressions I get about the case, I would say this. That case, that petition, will either fall or stand on 2 main arguments. There is the argument by the respondents, largely, that don't look at the irregularities or illegalities in the processes. We just want to look at the figures, whether they are statistics or numbers or results, because they were defined as such, in court variously. We don't know what exactly those figures are. But anyway, they are saying, look at the numbers and therefore the case settles. If the court focuses on the numbers and ignores to make a finding on A, what is the impact of an illegality, however small, or B, what is the impact of the irregularities, and how big do the irregularities have to be in order to affect the case one way or another. If they focus on the quality of management of the election and the functionality of IEBC and the application of the law and the technology, then one would say that that petition has very high chances of success. But if they focus on numerals only, then there would be an issue.
But I mean, to develop that position further, I got the sense it's not just the numbers. They're saying, well, there could have been problems, there could have been issues, there could have been mistakes. I'm not sure they said there could have been illegalities, but they said there could have been errors and everything.
Those
but
are what we call irregularities.
Yeah, the argument seemed to be that the judges should think about whether these things were big enough to have alter the results. And that's, I guess, is what you are saying, that if the focus is there, then it's a different approach, or it's a different conclusion that can be arrived at. But the other side would be that whatever may have happened, if it was illegal, then let's not even think about the magnitude or whatever. Is that what I'm understanding?
That's the point. That's the point.
Yes. You could further that because the question I think we have to ask is, based on everything that has been said, what are those things that the judges now have to decide? What are those questions? Because remember, initially there was supposed to be the framing of the questions, but then the judges said, well, you know, everybody come and argue whatever you have framed the questions to be. But at the end of the day, I'm sure the judges will be coming and say, from everything that was said, we think these are the things that we have to rule on, isn't it?
Yes, and that's the part that I find a bit unfortunate, that the parties could not adequately agree on framing the issues. Because once the issues are framed, then even the way you lead evidence becomes easy. When you've got 14 days, and you come, for example, with the case that the petitioners have, and you've got, just off the bat, 28 issues, we have 14 days. You've got 7 judges. There are so many parameters that come into play to ensure that are you going to adequately prove your case? Now, what Harun says about us having a game of numbers rather than looking at the procedure and the mistakes, sometimes I find that argument a bit dishonest, because the election rises and falls on the numbers at the end of the day. If we're looking at whether the elections are credible or not, whether there were mistakes or not, all those things come to the information at the end of the day. With all these things, will it subvert the will of the people of Kenya, or will it correctly reflect the will of the people of Kenya? That's what Section 83 of the Elections Act
They don't go as far as
they
don't go as far as ask the question whether whatever happened made it impossible to know what the numbers were, because someone might say that.
That was the problem we had with the Kriegler report, when he said it has become impossible for us to know. And that is why we are looking at verifiable. We are looking for credible,
exactly. I was coming there because verifiable would suggest that whatever happened, if it happened in a way that makes it difficult for us to know, then it means the numbers perhaps become irrelevant because you don't know.
The numbers become moot.
Yeah. And no, one thing that we must admit is that when Kenyans
and by the way, we are supposed to close this broadcast, so this will be your last remark.
When Kenyans went out to vote, they said something. What we need to be construing is, what did the people say? And even when the petitioners have gone to court, that's what they want to find out, the clarity. In this whole process, was the voice of the people correctly heard? If it was not correctly heard, then what do we do? Is it enough, was the silence of the voice of the people enough for us to need to repeat the process? Or was the voice heard loud enough for us to make sense of this entire process? So that is what even the question the LSK was dealing with, the constitutionality or otherwise of Section 83, that's why it rises and falls. And even with the other election petitions that we're seeing across the country, the only 22, is because you have to prove how whatever happened in your particular locality would have affected the outcome in your detriment or in your favor.
Elections are not mechanics. Yeah. It's not about mechanical process that you get your ballot here, register, you get your ballot, vote, let it be counted, let us have the outcome. There are standards and expectations of that voice of the people, which has been anchored in the Constitution, and especially because it's supposed to be an insurance policy for the future, so that we don't get back to 2007 on account that we can trust that the election management body will not subvert that voice on account of the power it enjoys, that it has all the mechanics, all the infrastructure, that it can actually subvert that ballot which I cast at the polling station without me asking questions as to how was there fidelity and integrity and how it was managed? That is the substantial question which I think my colleague is running away from, to say, let's count numbers and call them the voice. Numbers are not the voice. The voice is the spirit in the law.
Anything. All I'm saying at the end of the day, those queues were people who voted, every vote must count for something.
Okay, great. We have to end this. Obviously, we should have had 2 hours to do this, but there's still a long wait, so who knows? We may still continue this conversation. But for the time being, we need to take a short break, because coming up in a short while is the news updates that we'll be receiving. Remember, we are still waiting for that report to be submitted in court, and whatever submissions will come after that. For now, have a lovely evening. My name is Joe Agayo.
The standard of proof in a case is the degree to which the petitioner is required to prove his case.